Getting people to take their medicine is harder than you might think. The Federal Agency for Healthcare Research and Quality reports that studies have shown consistently that 20 to 30% of medication prescriptions are never filled, and that, on average, 50% of medications for chronic disease are not taken as prescribed. The repercussions are significant, both for patient health and for the healthcare system as a whole. Each year, the United States healthcare system incurs an estimated $100 to $289 billion in direct costs that could be avoided if patients filled their prescriptions and took their medications as prescribed. The most straightforward way to get people to take their medicine, or, to put it more formally, to improve medication adherence, is to remind them to do so, whether in person or by phone, email, or letter. On September 5, 2013, Adheris, a company that has made it its business to remind people to take their medicine, sued the United States Department of Health and Human Services, challenged the legality of regulations implementing the Health Information Technology for Economic and Clinical Health Act, more commonly known as the HITECH Act. Adheris contended that the new regulations restrict the ability of for-profit companies like itself to use patients' protected health information to target refill reminders and other communications designed to encourage medication adherence. The case is an example of the conflicts that can arise between our desire to improve healthcare quality and our commitment to protecting personal health information. As it explained in its court papers, Adheris enters into contracts with pharmacies, and the pharmacies then release information, including patients' names, addresses, and the medications they have been prescribed, to Adheris. The information in question is protected by the Privacy Rule, issued pursuant to the Health Insurance Portability and Accountability Act of 1996, better known as HIPAA. Adheris uses the HIPAA-protected information to send a series of letters to the patients on the pharmacy's letterhead. Adheris provides the patients with information on their medicines when they first fill their prescriptions, and then reminds them to refill their prescriptions when the time comes. Pharmaceutical companies pay Adheris for its services, and Adheris, in turn, pays the pharmacies. In its court papers, Adheris claimed that the patients who receive its letters are 2 to 7% more likely to be on their therapy at the end of the program period. Turning now to the challenged regulations, the general rule under HIPAA is that if a covered entity like a pharmacy wants to use or disclose a patient's protected health information for marketing purposes, the pharmacy must get the patient's permission first. Prior to the HITECH Act, refill reminders and other communications about a drug a patient was currently taking were not considered marketing. Refill reminders were considered treatment communications, and as a result, a patient's protected health information could be used to generate them without that patient's prior authorization. Under the HITECH Act and its implementing regulations, by contrast, refill reminders that a pharmacy is paid by a pharmaceutical company to send are considered marketing, unless the financial remuneration received by the pharmacy is reasonably related to the cost of making the communication. In the preamble to the new regulations, HHS explained that if the financial remuneration paid to an entity, such as a pharmacy, covers costs other than labor, supplies, and postage, or if it is enough to generate a profit for the entity, HHS would not consider the financial remuneration to be reasonably related to the cost of making the communication. The required relationship would be missing if, for example, the payment a pharmaceutical company made to a pharmacy to send refill reminders covered the extra hardware and software required to keep protected health information secure. As a result, the refill reminders would be considered marketing, and it would be necessary to secure each patient's permission before they could be mailed. HHS interpretation of a reasonable remuneration would have spelled the end for Adheris' core business. The payments the company receives from pharmaceutical companies allow it to earn a profit and also to cover expenses beyond labor, supplies, and postage, notably the costs of keeping patients' data secure. Adheris would therefore have had to secure patients' permission in order to continue to send refill reminders, but securing such permission would not, the company alleged, be economically feasible. In the preamble to the new regulations, HHS wrote that several commentators noted that it would be unrealistic to expect a covered entity to perform such non-essential functions as sending refill reminders and other related communications if they could not recoup both their direct and indirect costs as well as a modest profit. In its lawsuit, Adheris argued that the refill reminder provisions, as interpreted by HHS in the preamble, violated the First Amendment to the United States Constitution, which, among other things, protects the right to freedom of speech. The company contended that the provisions impermissibly distinguish among speakers based not on the government's legitimate interest in protecting patients' privacy, but rather, quote, on impermissible hostility to the financial motivation underlying the speech. The company also contended that the provisions restricted more speech than necessary. The government, Adheris suggested, could achieve its goals in other, less speech-restrictive ways. For example, the government could require that patients be given the opportunity to opt out of receiving refill reminders, as opposed to the more onerous requirement that they affirmatively opt in to receiving them. The government could also require that refill reminders disclose the fact that they were paid for by the pharmaceutical company, not the pharmacy. On September 19, 2013, HHS responded to the concerns raised in Adheris' lawsuit by issuing a guidance in which it changed its interpretation of reasonable remuneration. Under HHS' new interpretation, pharmaceutical companies can pay pharmacies enough to cover the cost of a refill reminder program, including capital and overhead costs, in addition to the previously approved labor, materials, and supplies. In addition, Adheris and companies like it can be paid the fair market value of their services, an amount that would include a profit. As long as the remuneration paid to pharmacies and to Adheris and companies like it conforms to these new requirements, they can continue to send refill reminders without first securing patients' permission. The new HHS guidance appears to address Adheris' concerns with the refill reminder provisions as originally interpreted. Even if Adheris' suit goes away, however, other disputes are likely to arise over where to draw the line when the efforts to improve healthcare quality have the potential to infringe on patient privacy, particularly where, as here, for-profit companies are involved.